Breaking news. Breaking news. Let me go ahead and bring on Flying Rich. And the breaking news is that my contract was canceled. So yeah.
So you're going to be poor living in a cargo container just like me?
No. I doubt it.
I can move some of my stuff to the side and you can...
Yeah, I'll be able to get another day job.
Unlike me.
I don't know how long it's going to take, but I'm working on another day job. Hopefully.
Did we mention we're sponsored by XTech? Did we mention
you
use code Crumpy?
Yeah, use code Crump10 and you can get 10% off. And that would really, really help me now because I'm going to be depending on those sponsorships more than ever now. See, Richard Briscoe. Don't like the intro, but whatever. Today we're going to be talking about what is going on, and this is a case that is basically it's a Hawaii case that went up to a 3-judge panel in the Ninth Circuit, and this is Lopez versus the city county of Honolulu. The people that argued it, the lawyers in this case, happen to be good friends of us, Alan Beck and Steven Stimbolia. So we're going to go through this, and Rich will read, and I will keep it going.
Okie doke. You want me to read this page or no? All right, good. I don't want to read those names. Those names were challenging. Okay, so summary. Second Amendment. The panel affirmed the district court's summary judgment for Todd Y. and David K. in their action seeking declaratory and injunctive relief to prevent the Attorney General of Hawaii.
Yukutaki.
Exactly, yes. From enforcing two provisions. Wait, you're correcting me?
In Kikawawa. I'll just read their names.
Of Hawaii's firearm laws and on the ground that the provisions violate the Second Amendment. First, plaintiffs challenge the constitutionality of Hawaii revised statutes, which provides a narrow time window, originally 10 days, now 30, within which to acquire a handgun after obtaining the requisite permit. The permit application process includes a background check. Second, plaintiffs challenge statute to the extent that as part of Hawaii's firearm registration process, it requires a gun owner within 5 days of acquiring a firearm to physically bring the gun to the police station for inspection. The district court concluded that the challenged aspects of both provisions were facially
Well, you can actually click on the fly down below.
Oh, no way. Yeah. Unconstitutional. Hold on. I see that. That's cool. Unconstitutional under the Second Amendment and permanently enjoined their enforcement. The panel denied the state's motion to dismiss the appeal as moot due to the recent legislative amendments to both the challenged provisions, which is a BS move by them.
Yeah, we're going to get to that in a second, but finish this paragraph, then we'll talk about that.
Sure. The amended provisions were sufficiently similar to the previous versions that any presumption of mootness was rebutted.
Okay, basically what happened was there's a time period where you get to purchase a permit, and I do believe, like Mitten State, that any purchased permit is unconstitutional. But Hawaii had a time period where you had to exercise your right within a certain time period or you lose it. Stephen and Alan, which are both great lawyers, Alan Beck and Steven Stimbolia, took the case. And I actually called Stephen, and he's in his underwear, so he can't come on. But just joking about that. But I did talk to him.
The chickens. Oh, that's Olsen with the chickens.
Yeah, Olsen's with the chickens. But what happened was Hawaii lost at the district court level. And I guess when they saw the makeup of the 3-judge panel, they thought, well, we're going to effing lose at the circuit court level. So let's go ahead and change the law to try to moot the case. We have seen this be used.
Move the goalpost so I don't get an L.
Yeah. So we have seen, well, they want it. They don't want to negatively affect other states that have similar things.
And have precedents.
Yes. So they changed the law, and they were like, "Oh, it's moot now. We changed the law."
No, you can't get me.
And the circuit court said, "No, that's all right."
I just have one like crazy comment. So you have to bring your, not only do you have to get a permit for your gun, you have to purchase it in a certain amount of time. So the hurdles, and now you have to bring your gun to the police station. It's like, hey, I got my gun here. Don't shoot me. This isn't suicide by cop.
Okay, here's a good question, because we're not going to read all this, because we're probably going to be coming back on around 2:50, because there's going to be a press conference, and I think you guys might find what is going to be said in that press conference interesting. Not that I have any inside information or anything. It might involve Pam Bondi and Trump, but I have no inside information on that. Shouldn't this affect New York and other states' licensing schemes because a right delayed is a right denied? Yeah, well, here's the thing. That's why they try to moot the case, because now other people, and they can do it on the district court level, but on the circuit court level carries a little bit more weight. They can file what is called a writ, a motion of supplement damn it. Oh my God. A motion of supplemental authority in those other cases in reference the 3-judge panel's decision.
Say, hey, they did this. But this again, like, you want to ride at the front of the bus? Well, if you file a permit 5 days prior and you pay a fee, penalty, whatever you want to call it, and then you decide you're going to ride the bus in the next 5 days, that's okay. You can ride anywhere you want on the bus.
Yeah, we're going to skip a little bit of this. But I just want to explain the whole entire thing right here, where they have to do a Bruin test on this, right? The first step of Bruin test, is it consistent with the text, the original text of the Second Amendment? That means they're going to look at the original text. Are the plaintiffs members of the people? The people to the courts mean the political class, anyone that who reaches the age of majority in the United States, which is 18. So obviously these guys are members of the political class. Then it moves to step 2, which is if the law is consistent with the nation's tradition and history of firearms regulations from the founding era. And I've said this a lot. There's some type of argument. I know the Second Circuit considers 1868 being the founding period. It's one of the reasons why there's a circuit split in Bruin.
Well, that's because they could draw a circle around the race system.
Yeah. The Ninth Circuit is more inclined to use 1791, and that's what they used here. So at this stage, the plaintiffs or the defendants have to present historical analogs to say, this is consistent. Here are laws from the founding eras that are relatively similar. Now, remember, in Rahimi, they said it does not have to be a historical twin, but it has to be relatively similar. And the further away you get from the founding era, the less weight those laws have. And Hawaii does not have any founding era laws that are even remotely similar to this. So I think we're on opinion now, Rich.
You mean I can give my opinion?
No.
Oh. So plaintiffs' appellates Todd Y. and David K. filed this action seeking declaratory and injunctive relief, preventing the Attorney General of Hawaii from enforcing 2 provisions of Hawaii's firearm laws on the ground that those provisions violate the Second Amendment as incorporated against the states by the 14th Amendment. First, plaintiffs challenged the constitutionality of Hawaii revised statutes, which provides only narrow time window, originally 10 days, now 30, within which they have the time to acquire a handgun after obtaining the prerequisite permit. Second, plaintiffs challenge to the extent that as part of Hawaii's firearms registration process, it requires the gun or within 5 days of acquiring a firearm to physically bring the gun to the police station for inspection. The district court granted summary judgment to the plaintiffs, concluding that the challenged aspects of both provisions were facially unconstitutional under the Second Amendment and permanently enjoined their enforcement. And let's see, they affirm. Plaintiffs Todd Y. and David K. are firearm owners who reside in Honolulu County and
Yukutaki and Kikukawa. Are you surprised I can't pronounce any other words, but I can pronounce their names?
Yes, and wish to acquire additional firearms in the future. They brought this action against the Hawaii Attorney General. Ooh, and I can click the page. No way, that's so cool. Hereinafter, simply Hawaii or the state, seeking declaratory and injunctive relief against enforcement of 2 Hawaii statutes concerning the permitting and registration of firearms. Plaintiff's operative complaint alleged the 2 challenged provisions unconstitutionally infringed the Second Amendment right to keep and bear arms for self-defense, both as applied to the plaintiffs and as a facial matter. Specifically, plaintiffs challenged one particular aspect of the permitting process that is described in the law of Hawaii revised statutes. Importantly, plaintiffs' complaint did not contest Hawaii's general requirement before acquiring ownership of a firearm. A person must first procure from the chief of police of the relevant county a permit to acquire the ownership of a firearm as prescribed in section blah. To acquire such a permit, a person must submit an application that includes specified identifying information about the applicant's mental health history and a signed waiver allowing the police to obtain mental health records. The applicant must also be fingerprint photographed by the police department unless the department already has such information on file. To allow the police department to conduct a background check, no permit shall be issued to an applicant earlier than the 14th calendar days after the date of the application. The one aspect of the permitting process that plaintiffs challenge below is the following provision: permits issued to...
By the way, we'll get into what is going on.
Okay. To acquire any pistol or revolver shall be void unless used within 10 days after the date of issue. This short period of time to acquire the firearm applies only to permits concerning pistol or revolver, and there must be a separate application and permit for each transaction involving a pistol or revolver. With respect to rifle or shotgun, by contrast, the statute states that such permits generally shall entitle the permittee to make subsequent purchases of rifles or shotguns for a period of 1 year from the date of issue without a separate application and permit for each acquisition. Mr. Y alleged that on one occasion in early 2019, he was unable to acquire a permitted handgun within a 10-day window and therefore had to start all over again with a new application. The second...
Yeah. See, that's the problem. If you get it, and let's say you have to work, but when your permit comes back, they're like, all right, your permit's approved. But I got to work for 10 days straight. I can't make it there. You have to start all over again.
That's crazy. If you don't get a permit to purchase and you order a gun, sometimes shipping, blah, blah, blah. It's not Amazon. They don't just drop guns off by a drone at your house. Shipping could have delays. That's not reasonable.
You're right. All right, keep on going.
The second challenge asserted by plaintiffs involves one aspect of the post-acquisition firearm registration process set forth in law blah, which provides every person who acquires a firearm pursuant to section 134-2 shall register the firearm in the manner described by this section within 5 days of acquisition. The registrant must complete a standard form that includes inter alia, the name of the manufacturer and the importer, model, type of action, caliber, gauge, serial number, and source from which the recipient was obtained, including the name and address of the prior registrant. plaintiff's complaint did not challenge either the underlying requirement to register a firearm or obligation to provide the specific information in connection with such registration. Rather, they challenged only the requirement that as part of the registration process, an individual firearms purchaser had to bring the gun to the local police station for physical inspection. Specifically, plaintiffs challenged to the extent that at the time of the district court's ruling in this case, that subsection provided that except for firearms registered by authorized dealers, all firearms registered under this section shall be physically inspected by the respective county chief of police or the chief's representative at the time of registration. According to...
Right, let me explain this a little bit because this is key. Basically, you had a certain amount of days where you had to bring the gun in for inspection. But one thing is very, very... Peanut, I'll get to it in a second. One thing that is very, very, very interesting is that, have you ever been to like Hawaii, where Honolulu is and stuff like that?
No.
The island is really, really big, and there's one police station in Honolulu that you have to bring it to.
Oh, shoot.
So you can be 2.5 hours away, and you had to bring it twice. So you had to do everything at the police station. So you could be 2.5 hours away, and their time limit was very, very, very limited. So basically, if you want to buy a gun, it was going to cost you 2 days of leave from work to be able to purchase that gun.
That's crazy. Again,
10 hours of driving at the farthest point in Hawaii.
Yep. And I always relate it to riding in the back of the bus. If you want to ride the front of the bus, just go to the police station twice, get your permit, get fingerprinted, photographed, and give all relevant information, DNA sample.
Yeah.
Next paragraph?
Yeah.
Okay. The parties filed cross motions for summary judgment on August 16, 2021. The district court granted summary judgment to the plaintiff, see Mr. Y, supplemental third at 1090, applying the intermediate scrutiny then applicable under Ninth Circuit Court law. The district court facially invalidated both challenged provisions. Specifically, the court first concluded that Hawaii failed to show that there is a reasonable fit its stated objective of promoting public safety in the 10-day permit use period.
Because they tried to say, oh, it's for public safety. And their reasoning was, well, maybe within those 10 days, after those 10 days, they might commit a crime and become a prohibited person. Not even taking in consideration that they're going to have to pass another background check when they buy the gun.
It doesn't matter. Whatever square peg.
All right, let me just say, I just want to cover this. Peanut was shut the hell up. I love you, Peanut. No, there's a press conference at DOJ today with Bondi and Trump, and rumor is that they're going to be addressing the Second Amendment stuff. That's the rumor. I don't know if it's true or not, but we'll have to find out.
And you know nothing about it otherwise.
That I just know the rumors.
Mm-hmm. Okay, if you say so.
But we're probably going to watch it live and see what happens.
Okay. Blah, in-person firearm registration. I'm just going to skip to the next page since I can do this myself. In subsequent September 23rd, 2021, order, the district court clarified that it had not invalidated whatever sections in toto, and that instead the 10-day permit use period and requirement in-person inspection and registration are severed from their respective statutes and stricken.
So
in
it
the
didn't knock down all Hawaii gun laws. It knocked down that one.
basically line item veto.
Yeah.
And I have issue with that, but I'll save that for later. In the same order, the district court also partially granted the state's motion for a stay pending appeal, holding that the injunction against the 10-day permit use period in HRS blah should be stayed, but the injunction against the in-person inspection registration requirement in HRS blah would not. The district court entered final judgment the same day, and Hawaii timely appealed.
So basically, they said it. Well, we're only going to give you a stay on some of it. Some of it's just way too crazy to get to stay that part. So that part's dead. The other part will stay until you appeal.
Shortly after the completion of the briefing in this court, the Supreme Court issued decision NYRSA versus Bruin. Thank you, Judge Thomas. Was that a 6-3 Supreme Court decision?
That was a 6-3 Supreme Court decision.
Did it change the face of the Second Amendment forever?
It did change the face of the Second Amendment forever. That's not an exaggeration.
Okay. Which rejected the then existing framework, the circuit courts, including this court, for evaluating Second Amendment claims. A motions panel of the court denied the state's motion to vacate and remand for reconsideration in light of Bruin, and instead granted the state's alternative request for supplemental briefing.
Basically, Hawaii says, "Can we just do a do-over because of Bruin?" And the court's like, "No, just give us the supplemental briefing. It's not going to help you out. So it's going to hurt you more than anything else."
We first addressed the state's contention that recent legislative developments have mooted this case.
And we've already talked about that, so we can skip.
I'm going to skip. Not long after oral argument in this court, the Hawaii legislature passed a bill which would amend both the provisions challenged by the plaintiffs. While that bill was awaiting the governor's anticipated signature, the state moved to dismiss this appeal as moot in light of this.
Yeah, but that let me just say, they wanted to moot it before the governor signed it. Which could be an issue because let's say they didn't moot it. What could the governor do then?
Yeah,
he could veto it, but the case is over, so they would have to start the case again.
So, in spite of this legislative development and to vacate the district court's judgment, plaintiffs have opposed the state's motion, arguing even if the bill was approved by the governor, the case is not moot. The bill was subsequently signed by the governor June 2nd, 2023, and it contains two relevant...
You can keep on going down.
Skip forward?
Yeah, because we already talked about it. It's going to get into Bruin and Rahimi, and I already discussed Bruin and Rahimi ad nauseum in the past, and also that. So you can go ahead and skip, I think, most of it. So it just goes through how it tested Rahimi and breaking down the laws. But
we get to a summary somewhere. Oh my God, there's 97 pages?
Yeah, that's what I said. They go into deep detail how they debunked everything. But go down to page 55 because there's some concurring and some dissent and a dissent. So
hold on, 55. Okay, right here.
Yeah, just read the final thing.
We therefore affirm, or
yes,
we therefore affirm the district court's conclusion that the in-person inspection requirement violates the Second Amendment. As with the plaintiff's challenge to 134-2E, we remand to the district court to revise its permanent injunction as appropriate in light of the recent amendment to 134-3 to conform to our ruling. For the foregoing reasons, we generally affirm the district court's judgment, but we remand to the district court with instructions to revise its judgment in light of the recent amendments to challenged laws. Affirmed and remanded.
So basically saying we agree with what you said, but you got there the wrong way. So just go ahead and rewrite it, but use what we're telling you.
So I specifically have a beef with the separation of, court, basically the branches of government, the legislative, the executive, and the judicial. That the courts should not be rewriting legislation. The legislation is either valid, constitutionally valid, or not.
What are you talking about?
This is like an overall. The court shouldn't be rewriting law.
Well, they're not rewriting law.
Well, there was mention of that, but anyhow.
No, they're remanding it back down to tell them, not to tell the legislature, to tell the lower court to rewrite the decision.
Right. So they're rewriting the law effectively.
No, they're rewriting the decision.
Okay.
It's not going back to the legislature. It's going to the district court.
I mean,
I have to enter the judgment, which he already came to, but using their stuff. So it's not going to the legislature. They're not talking about the law. Well, they are talking about the law, but it's not like to rewrite the law. It's to knock down the law.
Gotcha.
So it's going back to another judge, not to the legislature. It's still in the judicial branch.
Yep.
So they're not saying rewrite the law. They're not saying, that's not what they're saying. Did you get a little bit confused about that?
No, I think it's like in my mind a difference without a distinction.
Well, they're not changing the law. How do you think they're changing the law?
Well, two things. So they're talking about the amount of time that they have to one, get the permit. So you get a permit for a gun, the amount of time you have to receive the gun, and after you receive the gun, the amount of time that you have to bring it to the police station. Now, the law was changed to increase those time periods.
Yeah, but the courts didn't order that to be done. That was done to try to moot the case.
Right.
That wasn't done by the court. The court didn't say, hey, you have to do this. They did that to try to moot the case. So I still don't get your point.
Anyhow, let's just keep going.
Is that you saying that I misread something and I don't want to explain how I misread?
No. I just generally, an overall framework, the legislative branch makes law, and the judicial branch should not be editing the law. They should either say it's constitutional or not. And
they didn't edit the law.
Not specifically in this case, but in general.
Yeah, but what does that have to do with this case?
Well, it seems like there were portions where they're talking about, hey, change this and it'll be okay.
No,
unless I read it wrong.
No, they did. They're allowed to say, well, not to change it, but like, we figure that this is too long. They're allowed to say, well, if it was this long, then it probably wouldn't be too long. They're allowed to say that, or too short. They're allowed to say that. They're not allowed to say you need to change this.
Right, but I mean, look at Roberts changing the Affordable Care Act.
Yeah, that's a different case than this.
Yes, and that's what I'm saying. I disagree with the judicial branch stepping on the legislative branch's rights.
But they didn't do that in this case.
All right, then I read it wrong.
No, all they said is like, hey, this we think this amount of time would be constitutional. That's what they're saying. I don't agree with them on that. But they're saying yeah, dicta. It's dicta. They're allowed to do dicta.
Can I push a button on my desk and get oh, hold on. Does this button get me the ice cream cone?
No, whatever. They're allowed to do dicta. I mean, dicta is always there.
Johnny 3 bar. Love it. Love it. Yeah. Let's say you're bringing your gun to be inspected. You get pulled over for going 2 miles over the speed limit with an uninspected firearm.
Well,
What then?
you have a waiting. You have
A
a
get out of
grace
jail
period.
free pass.
You have a grace period.
But, they could anal inspect you.
Yeah, yeah, that would not be good unless you like that type of stuff.
I just, first off, most police don't know what end of a gun is what. So what are they going to know from inspecting the gun that you received?
Well, then they're not looking at the gun. They're verifying information on the gun.
And the
Make,
FFL can't
model.
do that?
No, they could, but it's just to make it a little bit more painful. They're make, model, caliber, and serial number is what they're looking at.
Mm-hmm. I'm so glad that we have a constitutionally protected Second Amendment right, because something like a privilege on riding anywhere on a bus, I mean, who knows what would happen with that?
Yeah.
Lightning Scott, I somehow don't think you're 3D printing anything that goes pew in Hawaii.
Yeah, I think Hawaii, everything has to be serialized. That could be wrong. I do have a comment because there's something that's important that we got to keep in mind here. And I'm gonna read a comment, or I did a request or comment to Steven Stambolia. He writes, "I am pleased that the Ninth Circuit panel ruled in the favor of the 2A, but given the previous wins Alan and I have had and received at the Ninth, including Young and Teeter, it's hard to get too excited knowing that an en banc hearing is no doubt likely to happen." Because what Hawaii is going to do now is they're going to ask for en banc hearing, because you got to remember this is a 3-judge panel.
So when did this ball start going down the hill? It was it 2021, because that's the earliest date I've seen.
Which one?
This whole case. When did this start?
2021, before Bruin.
Oh, okay. And so it's incredibly frustrating that it's 3 frickin' years later. A right delayed is a right denied. This is crazy how slow the courts move.
Hey, they move very, very slowly. In 2019.
So 5 frickin' years.
This, yeah, 6 years.
It's right to a speedy trial.
Yeah, well, it's been at the circuit court level since 2021.
That's pretty annoying.
Yeah, I think that they're gonna, since this went like pro Second Amendment, I think they're gonna grant en banc pretty soon to try to get it done, because right now the law is verboten.
But so now here's the whole thing. If you're Hawaii, do you really want to go en banc? You want to push it forward, or you just want to take the L and move on?
No, they're gonna go en banc if they'll win en banc.
All right, but if they win en banc, the next thing is what?
Is SCOTUS, but it doesn't necessarily mean SCOTUS is going to take it.
Okay, so
they're probably not going to take it.
So
there's so many cases that go up to SCOTUS, they concentrate mostly on the ones with circuit splits and
stuff
like that.
So the en banc, if they get a anti-2A win, that might be the end of it, unless it goes to SCOTUS, and like you said, they might not take it, so certiorari, and then it might still be a year plus out. So it's kind of a win-win if they're delay deny is their tactic. They might just still win for another couple of years if it doesn't get picked up at SCOTUS. And I guess their plan would be to count that it doesn't get picked up by SCOTUS, and that they have the bad law. It's amazing to me. Bruin is pretty plain and simple about how you judge these things, and that they would go against it. But they're activists. I mean, that is the definition of an activist court.
Yep, yeah, exactly. There's lots of activist judges out there. There's lots of activist judges there. So we'll have to see what happens here.
It's a train wreck. I mean, this is like one of the reasons I'm out of New York, because New York is a train wreck. Either that or a toxic waste
Yeah.
spill.
In Yonkers, yeah.
Oh, it
Go check out Mud and Munitions. He did a live stream of some like toxic.
So
like,
he asked a cop. So there's dozens of police cars, helicopters flying over, drones in the air, and he asked a cop what chemical spilled. He's like, "Oh, it's nothing. It's nothing to worry about."
He probably doesn't know, to tell you the truth.
Right. It's like milk. It was milk. This is the standard response team. We have decontamination tents.
Yeah, but you do that. I mean, I've been on plenty of hazmat scenes when I was a firefighter, and you always do that. You always treat everything, no matter how little the spill is, as a
So it could be some chemicals they use to treat the water in Yonkers. That's what it could be.
Yeah, that's what I'm thinking. It probably could be.
That's most likely.
Yeah, that's what I'm thinking. But like, anytime there's a hazmat response, you go
go ham.
Because you never know, right?
Mm-hmm.
It's better to be over prepared than under prepared. Why cannot the DOJ can sue the states over their gun laws? They just choose not to.
So Pam Bondi?
Correct. Well, maybe she will. I don't know. She's only been in there for a little. I'm going to give her a little bit of time, but I'm not too confident. I'm not too confident. Yeah.
Yeah. So what Jason says.
Thomas Jefferson notes on Virginia said that if any of the three branches interfere with the job of the other branches, that despotism, and we are not a free state. Exactly. Matt says she ain't doing shit. A Gun Day morning quarterback says she won't, and I agree with you, but always a chance. She gets pushed to do it. But I'm not a big believer in Trump's.
Maybe if the Republicans had all the Republican cabinet members do a choose your fighter boxing thing, maybe that would sway opinion.
Yeah.
Just a brand new idea I had. Not that I'm copying anyone ever.
Yeah, we'll have to see.
All right, my dog needs to go out and chase squirrels.
In me not saying something obnoxious than she does doing more for the 2A rates, unfortunately. Yep. All right.
So what time are we back? What time?
Probably in, I would say 30 minutes.
Okay. All right. I have time for lunch.
Yeah. And then after that, well, it's probably going to take an hour. Then we'll be gone for an hour. Then we'll be back again.
Happy Friday.
It is always Friday, right? We're out of here.